us soon. So we should start now.
Yes, sir. So a very good evening to everyone. I am Chirag Balyan. I am Deputy Director at Center for Research in Criminal Justice, National Law University, Mumbai, and I'll be moderating today's webinar, Taking Bail Seriously. Now, while everybody can understand that amid this corona pandemic, we should take corona seriously because it affects the life. But as far as personal liberty is concerned, bail is equally an important matter. And that's why the theme of our webinar, based on the seminal book authored last year by Salman Khurshid, Sidharth, Luthra, Lokendra, Malik, Shruti, Bedi, on taking bail seriously, we have devised today's webinar. And as all of you must recognize that the recent bail plea of Safura Zargar, wherein they have raised an argumentation of humanitarian ground, has resurfaced the necessity of relooking at the bail laws. And ultimately, it always comes to what is the objective of the bail. There are two ends of spectrum. On one hand, we have presumption of innocence. On the other hand, we have security. On one hand, we have personal liberty of an individual. On the other hand, we have dangerousness of an individual. And amidst these ambivalent ideas, we have the bail jurisprudence in between. And to discuss these issues, we have today some of the most eminent speakers in criminal law. Mr. Sidharth Luthra, who is not able to join us. He is a senior advocate at the Supreme Court of India. Mr. Sanjeev Singh, again a senior advocate at the Supreme Court of India. Professor Dr. Manoj Sinha, director at Indian Law Institute. Dr. Lokendra, Malik, an scholar and an advocate at the Supreme Court. And Professor Dr. Shruti Bedi, again professor at the University Institute of Legal Studies, Panjab University. With this small note, I would request Dr. Malik to give his opening comments.
Thank you, Chirag. Good evening, ladies and gentlemen. We are deeply grateful and we are lucky to have a very good panel of eminent criminal law experts today. Mr. Sidharth Luthra, India's most eminent criminal law practitioner, is with us. Mr. Sanjeev Singh, senior advocate, Supreme Court of India, and a very eminent lawyer in criminal law, corporate law, is with us. Professor Manoj, director, Indian Law Institute, is also with us, and my colleague Chirag Balyan and Professor Shruti Bedi and Professor Sheikh, they are also with us on this occasion. The webinar is focused on our book titled Taking Bail Seriously. We had published this book last year from LexisNexis, and that book deals with many issues relating to bail jurisprudence in India. Recently, the Delhi High Court has granted bail to Safura Zargar by using the remarks humanitarian grounds. I think this is not a good trend, because she is fully entitled to get the benefit of presumption of innocence, and whenever a court of law decides bail applications, etc., then the court should not go deep into the merits of the case and should see that if the accused is available for the trial or there is no apprehension of flight risk, in that situation, I think the accused has a very good case for bail. Unfortunately, nowadays, the bail norms are totally changed. Before a few years, bail was a rule and jail was an exception. But today we are witnessing a different kind of scenario regarding bail jurisprudence. So on all these issues, we intend to discuss all these issues pertaining to bail jurisprudence today. Mr. Sidharth Luthra will be keynote speaker And Mr. Sanjeev Singh will also share with us his ideas regarding bail jurisprudence, and Professor Manoj Sinha will also give certain inputs regarding bail jurisprudence in our country. My colleague Professor Shruti Bedi will introduce the entire project of taking bail seriously. And with these words, I once again welcome you all, and I look forward to discussing my eminent colleagues. Thank you very much.
Thank you, Dr. Malik, for setting the right tone by giving us two objectives. Is whether the objective of the bail is to ensure the presence of an accused, or is it to put the person behind the bar for the seriousness of the offense. And I think that's the central theme of the book also, apart from other central themes. And Professor Dr. Shruti Bedi now will expound upon this argument.
Thank you so much, Dr. Balyan. If I may just make a request to you or your technical team to keep everybody else on mute except the speaker, because
Mute.
there's a lot of
Yes.
background disturbance while the speakers are speaking. So you can put everyone on mute, and the host has that option of putting everyone on mute. It'll help the conduct
Sure.
of the discussion today.
Sure.
So good evening, everyone. It is indeed an honor and a pleasure to be a part of this panel and to have initiated the discussion on such an important topic of bail jurisprudence in India. Not only because of what Dr. Malik and Dr. Balyan have already talked about, but also because we recently, as a team, have published a book by the same title, Taking Bail Seriously, which has been edited by Mr. Salman Khurshid, former Minister, External Affairs and Law and Justice, Mr. Sidharth Luthra, Senior Advocate, who will be joining us shortly, Dr. Lokendra Malik, a Senior Advocate and an academician, and myself. And this is also the topic for today's discussion. The book actually has been dedicated to an illustrious criminal lawyer who is well known for his advocacy skills in the field of criminal law. That is Mr. K. Luthra, who is Mr. Sidharth Luthra's father. Mr. Sidharth Luthra himself, an eminent lawyer in the criminal field, has contributed immensely to the development of criminal law, especially in the field of bail. And he has, in fact, taken this legacy of the family forward. If I may say so, even though he's not present, that he is the go-to man for every person who is suffering and is inside jail, because they feel that he's the one who can get him relief. And many are people who have lost their hope have benefited from his labor and expertise. Mr. Sanjeev Singh, the second eminent speaker for today, a true gentleman lawyer, if I may say so. Sir, please accept my fervent admiration of every fine quality of your head and heart. Professor Dr. Manoj Sinha, who has also contributed a very crisp and a significant blurb message for our book on taking bail seriously. Sir, our warmest regard and esteem to you from the entire team of the book for adding to the academic character of this book. We are keenly looking forward to hearing you. And Dr. Lokendra Malik, nothing, if I may say so, is possible without this one-man army. Neither the book nor today's discussion, he brings life and energy to everyone around him. And sometimes I feel that he can even probably wake up the dead to make them do things which others can't. Sir, a salute to your contribution to legal literature, which is unmeasurable because of the fact that you have contributed not only 10 books, but so many more publications. And a quick word of appreciation for my colleague, Ms. Dr. Chirag Balyan, whose own article in the book is a unique contribution to the development of this jurisprudence. Well, Taking Bail Seriously is a book published by LexisNexis, an internationally known publisher, and it presents the actual state of affairs regulating bail jurisprudence in India. There is a wealth of information and solutions offered by experts, a variety of experts, a few among them. The foreword, in fact, is written by Justice H.S. Bedi, former Judge, Supreme Court of India. The afterword has been contributed by the very eminent Professor Upendra Bakshi. And there are other contributions in the book by Dr. Abhishek Manu Singhvi, Justice Saro, and many well-known lawyers and academicians in the field of this particular issue. The book is of extreme relevance to lawyers, to judges, to policymakers, to academicians, to law students, and any person who in general wants to know about what exactly do we have about bail, know about bail. So it covers so many issues. It covers issues of regular bail, default bail, transit bail, anticipatory bail, the constitutional rights of personal liberty and bail, the bail under special laws, electronically monitored bail. There is even a chapter on the comparative perspective of bail in India and Canada. There is a chapter on foreign detainees as well. So an extremely comprehensive work, which is a labor of love for everyone who has been a part of this team. And I would actually just like to end this introduction by what Justice H.S. Bedi has written in the foreword. And he says, the readers of this volume will acquire the skills that are rarely taught in the law schools. So all the very best, and looking forward to this discussion today. Over to you, Dr. Chirag Balyan. Dr. Balyan, I think you're on mute. You will have to unmute yourself.
Oh, I'm really sorry. So thank you, Professor Bedi, for the crisp introduction of the book and telling us what the book actually stands for and the wide variety of essays by the eminent authors which this book contains. Now I request Professor Dr. Manoj Kumar Sinha, Director of Indian Law Institute, to share his ideas on the bail laws. Sir, please.
Thank you very much, Dr. Chirag. Professor Sri Sidharth Luthra ji, Sanjeev Singh, Dr. Lokendra Malik, Professor Shruti Bedi, Dr. Sajid Sheikh, and all participants available over the Zoom. It's a great occasion for me to speak on this subject, which I have very limited command. Because, but I'll speak on the more on international perspective little bit. However, I'll speak on the importance of bail law. And as rightly pointed out by the Shruti Bedi regarding the book that Professor Shruti Bedi, Dr. Lokendra Malik, Sidharth Luthra, and Salman Khurshid ji has brought Taking Bail Seriously in month of November this last year, which contains almost 22 topics and very detailed analysis of bail jurisprudence in India has been done under this particular book. I'll just take this opportunity also to, in brief, inform all of you, and Dr. Lokendra Malik is very much aware that in same time, simultaneously, that Indian Law Institute has also brought a book on the bail law and practice in India. So there are two books we brought, and in fact, many occasions, Dr. Lokendra Malik and we have discussed. So the second book which we have brought, that is Bail Law and Practice in India, which covers more or less the topics which has been suggested, and particularly on the default bail, anticipatory bail, cancellation of bail, and other areas related with the legislations related with bail, constitutional jurisprudence, and other aspects. There are 9 topics are there. So both books are very important, and I can say that the first book, Taking Bail Seriously, will be definitely helpful for the researcher and students who have interest in criminal law. When we talk about the right to bail, and I think the amount of energy and amount of consideration uh, given by Honorable Justice Sri Krishna, Justice V.K. Krishna Iyer regarding the bail, and particularly in two important number of judgments, he spoke about the bail and he said bail or jail, and he identified and he always emphasized right to bail is a human right in general practice also. So we see, so in all human rights instrument under the constitution also, if you look into the article 21 and article 22, there's a safeguard. So personal liberty is very important, but liberty can be curtailed. It's lawfully, it can be curtailed if a person has committed something wrong. So legal procedure, but legal procedure has to be followed and a person can be detained. But a detained person is not guilty. It's a presumption of innocence is there. His fair trial is important. Speedy trial is there. His liberty and his right, his right to seek bail is also there. So these are very important part of the human rights instrument. And in case where a person who has been unlawfully detained and he has a right to seek compensation. We have seen in the national law, in the domestic perspective as well as the international perspective, individual who suffers in case of unlawful detention, he has a right to seek compensation from the state. That is very much there. There are two important areas when we talk about the bail. The first, bail is related. If we focus on the first, and I'm sure that two eminent lawyers are there, so I don't want to go much detail in this subject because that will be repetition. So Sri Sanjeev Singh is there and Sidharth Luthra sir, both are very eminent and both have worked. So I will leave that some areas, but in broadly I'll just touch. So I feel there are two broad areas which needs to be focused. The first is the bail pending trial. And if we focus on the bail pending trial, it covers more or less 60 to 65% under trial prisoners. There are a lot of persons in languishing in the jail and they're entitled to get bail, but they don't have money, they don't have resources, they don't have anybody to represent them in the court. So they are languishing in the jail. Many of them have also surpassed, even if they convicted, the time they have spent that is much longer than had they been convicted on a particular charge. So we see the situation is very serious when it comes to the under trial prisoners. If judiciary and jail authorities, legal aid services, lawyers, if they start taking note of this particular concern about the bail aspect, so many of the under trial prisoners will be free and they can enjoy their other human rights. Then other aspects, so a large number bail pending trial, that's a 60 to 70% cases are with that particular aspect. And then there is a bail pending appeal that is limited, but in the first case, we see the large number of cases are there. When we deny bail, so it's let me just right to bail is linked to right to liberty and right to fair trial. There are 2-3 important judgments which I would like to highlight here. The first, which I thought, and I'm sure that other other respected speakers will also speak, that is by Goody Kanti versus public prosecutor, where decided in 1978, and Justice Krishna Iyer has raised bail or jail. And what he said, that point is very important, which we need to ponder over. So I'm taking one particular paragraph, what he mentioned in bail in the Goody Kanti case of 1978. He says at the pre-trial or post-conviction stage belongs to the blurred area of the criminal justice system and largely hinges at the on the hunch of the bench, otherwise called judicial discretion. So there is a ample power judiciary has been given regarding when it comes to the granting the bail. Then another important case which we have, that is consideration that we may consider in the interim bail, particularly in the Nandini Satpathy versus PL Rani. That case was decided in 1978. a landmark case which we consider related with the anticipatory bail, which was again decided in 1980. So we see 78, 79, and 80, the very important judgments started pouring on related with the right to bail. So the another anticipatory bail, the case which I would like to highlight, that all of you are like, Gurbakh Singh Sibia versus State of Panjab. And then last case which I have in mind, which also like, Justice Krishna here, this was also one of the judge, that is State of Rajasthan versus Balyan, which was decided in 1974. Is bail not jail? And he spoke about the why bail is very important. So these are the some cases which I have highlighted, and I'm sure that other speakers will discuss about the more important cases when they give their presentation. Let me take you from here to the international level also. And then when we see in almost, it's not like the right to bail is officially mentioned in the all the human rights instrument, but what is there? It's a release. If a pending trial, a person can be released. And that we have find in all human rights instruments, and particularly starting with the Universal Declaration of Human Rights under Article 3, European Convention on Human Rights, African Charter on Human Rights, all human rights some way talks about granting bail to the accused for any matters. So that is there under in the international human rights instruments. In year 1988, the United Nations General Assembly also adopted a resolution. United Nations General Assembly, though it's not very hard law, it's a soft law, it's not very important, but it's very important in framing a law related with the right to bail in the national level, which state can take note of, though it's not a binding. But this resolution, which I'm talking about, the United Nations General Assembly resolution of 9 December 1988, it talks about, it lays down the principles for the protection of all persons under any form of detention or imprisonment. It provides, so this is the resolutions for the protection of all persons under any form of detention or imprisonment. It says, persons detained on a criminal charge shall be entitled to trial within a reasonable time. So first is a reasonable time. So if trial takes, speedy trial is very important. Within a reasonable time, which we consider generally at the international level, 4 to 5 years a trial has to be conducted. But what we see, it takes longer period in this semester. Within a reasonable time, or to release pending trial. So, or to release pending trial. Similarly, what we have noted under International Covenant on Civil and Political Rights, under Article 9 and Article 10, 9 talks about it details about a person's like judicial guarantees, or releasing a person on pending trial. So there are safeguards mentioned under the Article 9. And Article 9 and the end, because it has 5 subsections. So and it talks about the Article 9, which is very important, which I would like just to mention here. So it's like it deals out, it highlights about the procedure for the bail and if trial and other aspects, legal representation, all aspects it has discussed under the Article 9, paragraph 9, which has 5 sections. And the last section, which is very important, that is 9, paragraph 5. What it says clearly in the 9, paragraph 5, in case of unlawful detention, a victim has a right to seek compensation. A victim has a right to seek compensation. And as you, interesting part, so as many of you we are aware that India is a party of this. So one way we have an obligation to see that Article 9 is implemented as it is at the national level, because we are party of that particular instrument, and we have accepted the legal obligation on 10th April 1979. So after the emergency, we became party of the International Covenant on Civil and Political Rights. Interesting point which I would like to highlight here, Government of India, particularly the last paragraph, that is Article 9, paragraph 5, which talks about in case of unlawful detention, a person has a right to seek compensation. So at the time of ratification in 1979, what Government of India has done, Government of India has mentioned that there is no similar provision, neither in the constitution or any statute in India. And thus Article 9, paragraph 5 is not applicable to us. In a nutshell, what I can say, we have made a reservation for non-application of Article 9, paragraph 5. However, we see there are a lot of cases Supreme Court of India started giving compensation, and we have Husainara Khatun, and there are a lot of cases, Rudul Shah, Husainara Khatun, list goes on. And also in number of cases, court has cited specifically Article 9, paragraph 5 of the International Covenant on Civil and Political Rights. So there is no problem as such regarding the interpretation and application of Article 9, paragraph 5 by the Indian Supreme Court and also by the various high courts of India. So we are very progressive in that sense. Just to last point which I have, even under the International Criminal Code, which talks about the individual criminal responsibility, it also highlights about the release pending trial. And in fact, all the international criminal tribunals which came into existence in 1993, 1994, and also in 1998 International Criminal Court, which has come into force, what we see, all have a provisions, all have applied some kind of, so these accused are the accused for a serious crimes they have committed, universal crimes, but they are all very entitled to get bail if subject to the judicial discretion, of course, but there are provisions, there are protections. So what we see, even a person who has committed heinous crimes, a person who has committed serious crimes, if they convince the court that they are not going to run away, they cooperate with the court, they will not destroy the evidences, they will not disturb the witnesses. If this kind of assurance and court believes, there is a liberal interpretation has been done by the various international bodies. I think time has come, and I'm sure that we have a lot of people are thinking about. Time has come in Indian scenario also. The interpretation court has to become little bit liberal in granting of bail, and it has to be the more and in unfortunately large number of cases, because large number of cases they never move from the subordinate court to the high court or Supreme Court. So our in the lower court becomes the final court. If for the number 60 to 70% and maybe more for 80% people are ready to accept whatever the lower court decides, because they don't have a money, they don't have, poor people have no chance to go to the high court and Supreme Court for the seeking the bail. So large number of the people are languishing jail because the lack of resources, lack of legal representation. So there is a bigger role of the civil society, there is a bigger role of the academician, there is a bigger role of the pro bono lawyers. And I'm sure that the initiative which you have taken, particularly National Law School, Chirag, Balyan and Sajid, you people are there, and Dr. Lokendra Malik is there. We have to motivate our students, and many times we have seen that students have played very important role. Delhi University, faculty of Delhi University has a a particular student cell. They visit the Tihar jail and find out who are entitled to get the bail, and accordingly they process with the NALSA and the Legal Services Authority, and they help in getting bail of number of cases. So what we have to do, not only in the webinar discussing about the bail, we have two books, many books will come in the future, but same time we have to create soldiers, legal soldiers who can carry, who will working for the poor people, those who are desperately need some kind of legal assistance, and that will help them to come out from the jail and face the trial. And also by this we can protect the human rights. So generally we talk the state has a right, the state has a duty to protect the human rights, but it's not only state has a duty to protect human rights, it's we all have a duty. So we all have to play, and I'm thankful that Dr. Lokendra Malik has asked me here to speak, and I'm sure that the discussion which is going to take place, this has to be disseminated among the students of the law school, and there are a lot of law school students are there, and they have to devote some time for the underprivileged, weaker section of the society, those who are desperately looking for some kind of legal help and legal assistance. With this, I thank the organizer. I thank the Dr. Lokendra Malik, Professor Shruti, Bedi, and Chirag, Balyan, and Sajid, of course, Sidharth ji and Sanjeev for attending this conference and giving me an opportunity. Thank you very much. बहुत बहुत धन्यवाद आप.
Thank you so much, sir, for telling us what should be the principles behind the grant of bail by quoting international instruments. When you say that the emphasis should be on the flight risk, on the presence of the accused, and not on the seriousness of the offense, I think that's the most important aspect which we must keep in mind. And as I repeat again, this also again takes us to what is the objective of the bail. The wide discretion which you mentioned about, which the court exercise, has to be exercised keeping in mind these principles. Thank you so much, sir, for sharing your ideas and views. Now I request Senior Advocate Shri Sanjeev Singh, sir, to share his views.
Good evening, everybody. Can everybody hear me?
Yes, sir.
Okay.
Yes, sir.
Let me start first with the famous words of Justice Krishna Iyer, our famous jurist, who in the famous case of Narasimhulu had remarked that the subject of bail belongs to the blurred area of the criminal justice system and largely hinges upon the hunch of the bench, otherwise called judicial discretion. Now, the problem is these words, judicial discretion, which has resulted in such a large, wide variety of case law, different and divergent views of various benches, which is why we have come to expect different kind of verdicts from different kind of benches. Now, we have, our founding fathers have chosen to accept the adversarial system. Now, in the adversarial system, the judge occupies the most important position. On one hand, he basically acts as the umpire, and in our system, the burden is on the prosecution to prove beyond doubt that the accused is guilty. And if two views are possible, then the judge usually is expected to give the benefit of the doubt to the accused. Now, ultimately, in a matter of bail, the judge has to balance both the sides, as was eloquently described by Mr. Balyan and Dr. Malik. On one hand, there is the question of individual liberty, which is enshrined in Article 21 of the Constitution. And on the other, the societal interest and the fact that the police investigation ought to go on unhindered. Now, as far as the police investigation is concerned, you see, in fact, I was reading a very interesting article by Dr. Malik today morning, in which he has highlighted the recent high-profile incidents of police conduct, both in the United States as well as in India. A man named George Floyd was beaten up mercilessly and in fact killed in the state of Minnesota. And recently in our state of Tamil Nadu, a father and son duo was beaten up and in fact killed in police custody. Now, the third report of the National Police Commission had said that the 60% of the arrests in India were unjustified. Now, that's a very shocking number. Subsequently, there were several safeguards laid down by the Honorable Supreme Court in cases of Joginder Singh and D.K. Basu, which was heard for a long period of time. And various warnings were issued to the police to follow, even to the extent of warning the police that any procedure not followed would constitute a contempt of court. But unfortunately, scant regard has been taken of those warnings by the Supreme Court. In fact, certain provisions were incorporated in the Code of Criminal Procedure as well to make arrests more transparent. Now, in the year 2019, there were as many as 5 deaths per day in police custody. Between the periods 2009 to 2015, there were 2 deaths per week in police firing. Between 1996-7 and 2016, only 8 policemen were convicted. Only 8 policemen. Of course, the police conduct is one part of the story, but we must also remember that a section of our society also believes in complete disobedience and complete disregard of the law. And for this section, I believe deterrence seems to be the only factor binding this section. Therefore, the judge ultimately has to balance the equities, balance the interest of the individual, the liberty of the individual, vis-a-vis the interest of the society and the interest of the investigation which is being conducted by the police. Now let's go back to the definition of bail as we learnt in the law faculty. A bail is defined as procuring the release of a person from legal custody by undertaking that he/she will appear at the time and place designated and then submit himself to the jurisdiction and judgment of the court. The Supreme Court has also defined bail as a security obtained from a person arrested regarding an offense for the purpose of securing his presence during the course of trial. Now, how has the jurisprudence of bail progressed from time to time in the Supreme Court? The concept of bail lies in the doctrine of presumption of innocence. The presumption of innocence is the legal principle that one is considered innocent until proven guilty. However, Indian courts have applied inconsistent standards in connection with the law in respect of bail, failing to consider the ramifications of their decisions on the right to be presumed innocent until proven guilty. The lack of a uniform precedent allows the individual outlook of particular judges to become the controlling factor in deciding bail petitions and has led to the unnecessary incarceration of over 250,000 people pending trial, which is almost a staggering 65% of the total prison population. Now, denial of bail is permissible only for preventing the accused from absconding, committing further offences, tampering with the evidence, or influencing witnesses. Imposing restraints in such cases which inconsistent with the presumption of innocence is justified by public policy consideration, placing a premium on the sanctity of the judicial process. Thus, it is imperative for the courts to determine when the presumption of innocence comes into play and what are the overriding considerations that justify the departure from the rule of respect for the accused's liberty, and whether the administration of our criminal justice system and the bail law is effective and fair in achieving these objectives. The principle that is followed is behind bail matters may be summed up as bail is the rule and jail is the exception. Now that appears to be the line followed by the Honorable Supreme Court in the earlier cases. For example, Justice Krishna Iyer in the year 1977 held that the basic rule is bail, not jail, and except for the fact that the accused is expected to flee from justice or repeat offences or intimidate witnesses, bail ought to be granted. Justice Ahmadi in 1992 noticed the legislative anxiety for an early trial, which is unfortunately not the case in modern India, and also held that if two views regarding two views are possible, the views favoring individual liberty always must win, and the prosecution must complete the investigation at the earliest possible time. Justice Chandrachud in 1980, in the famous case of Gurbaksh Sibia, laid down the law in relation to anticipatory bail, section 438. And thereafter, Justice Banerjee in 2002 held that the discretion to be used has to be used in a judicious manner. And the three considerations which were set out was nature of the acquisition, tampering of the witness, of the evidence, and prima facie view of the court. Now, Justice Balakrishnan and Justice Sadasivam in 2004 to 2013 also held in favor of the accused that the conditions imposed ought not to be too onerous. Now, this appears to, so therefore the Supreme Court has for a long time in its jurisprudence favored the accused in several ways. And even at the current period of time, as we talk, in the time of Corona, the Supreme Court appears to have followed this liberal interpretation. Now let us see what the Supreme Court and the courts have done during the Corona. In the wake of the coronavirus, the Supreme Court issued regulation in its order, Recontagion of COVID-19 in Prisoners, Suo Motu Writ Petition 1 of 2020, and on the 23rd of March has in fact directed that a high-powered committee should be set up in every state and union territory, which would decide on the matters in which parole and interim bail should be granted for a period that may be thought appropriate. The paroles and interim bail so granted are being granted in order to facilitate decongestion and to ensure social distancing amongst prisoners. The committee shall constitute of the State Legal Services Committee Chairman, the Principal Secretary of Prisons, Home, Prisons Director General. Any specific alteration to the rights have not clearly been mentioned in the judgment. The high-powered committee is supposed to exercise complete discretion in deciding which class of prisoners are to be released on parole or who should be granted interim bail. However, in keeping completely open for the high-powered committee to decide, the basis of judging the matters are set out on the following grounds. One is the nature of the offense. Second is the number of years on which the prisoner has been sentenced. Three is the severity of the sentence, etc. Now, the Supreme Court has directed the states could consider the release of prisoners convicted or an accused for under trial for offences where the prescribed punishment is less than 7 years with or without fine, and the prisoner get convicted for lesser than the maximum. Now, there are several instances where the Supreme Court has denied bail in spite of the COVID crisis. One was by the Madras High Court and the High Court. The Madras High Court declined bail in an offence under the POSCO Act. The 59-year-old Christian Michael, who was accused under the August Westland scam, approached the Supreme Court for bail. That was rejected. Asaram Bapu, citing his old age of 84 years, was rejected bail by the Gujarat High Court. Deepak Talwar, accused of several economic offences, was denied bail. And as late of today, old man who has been convicted in the anti-Sikh riots case had in fact has got COVID. He himself has got COVID and he applied for bail. And today the Supreme Court has denied the bail to him. So therefore, what are the initiatives which were taken by different courts? The Supreme Court has extended the interim bail granted to an accused from time to time during the period of COVID. The Delhi High Court has done similarly and has said that this has been done to dispense justice and not to send messages to society while granting bail to a number of riots accused. The Delhi District Court has also been reasonably liberal. The Bombay High Court, as high-powered committee in Maharashtra, has decided to release 50% of the 35,000 odd prisoners in jail across the state. However, no prisoners who have been charged or convicted under the MOCA and other MPID, UPAPA, Prevention of Money Laundering Act has not been released. Chandigarh High Court has extended interim bails granted from time to time and has granted up to 15th August is what I'm told. Therefore, in light of the deadly pandemic, the courts seem to have adopted an approach wherein more importance has been given to life and liberty of an individual rather than keeping him behind bars. Although it's a welcome change, the proved benefits of such interpretation of bail jurisprudence can only be reaped if the courts continue this uniform approach even in normal times. Now, before this, however, the Honorable Supreme Court in many cases has adopted contrasting approaches in similar factual situations. Very briefly, in the case of Rajesh Ranjan alias Pappu Yadav, 10 bail applications in the trial and appellate courts had been refused. The trial had dragged on for more than 10 years. And in fact, investigation was completed. Therefore, there was no possibility of influencing witnesses or tampering with the evidence. But even in spite of a 10-year delay in conducting the trial, the Supreme Court denied bail to Pappu Yadav. In the case of Sanjay Chandra versus CBI, the Delhi High Court cited the ground of huge defalcation, allegations of huge defalcations to the tune of billions of dollars. However, the Supreme Court turned back to the old jurisprudence and held that the life and personal liberty was the most basic of fundamental rights, and therefore granted bail to the accused finally. In recent cases, the Supreme Court directly interfered and, of course, ultimately directed the respective high courts to consider. But in the cases of two journalists, Arnab Goswami and Vinod Dua, it did grant interim protection and thereafter passed directions for the respective high courts to decide on the matter. Earlier on, in the case of Gurbaksh in Sibia, a 5-judge constitution bench of the Supreme Court had again widened the scope of bail and had adopted a very liberal approach, which was again, I would not say dissented, but departed from in the case of P. Chidambaram versus Directorate of Enforcement by a 2-judge bench. Therefore, what would be the conclusions in the view of the above discussion? First is for the legislature. Really, I think the legislature requires to spell out the parameters far more clearly, and it is high time. And an amendment of the existing law also should be done to incorporate additional safeguards and expressly laying down its policy towards unnecessary detention. As far as the judiciary is concerned, in the articulation of the orders by the honorable judges on bail, the judge must relate reasons such as nature of the crime or severity of the charges, or to the assessment of the accused potential for interfering with the judicial process, should not act on perceived public interest. There is unfortunately too much of media trial going on at the moment. Even otherwise, the law should be interpreted to require courts to regularly determine whether the reasons advanced by the states for continued incarceration are justified, especially if the trial is prolonged, which is usually the case in India. The other thing is there should be a stricter burden of proof on the prosecution, which must bear the burden of proving that the public interest consideration outweigh the presumption of innocence and right to civil liberties. And the other aspect which may be considered is a compensation for wrongful detention. Subsequently, if the accused is acquitted, the law may provide for compensation for wrongful detention, deprivation of liberty, reputational sanction and associated costs. The present compensation is capped only at rupees 1,000. This is especially necessary in cases of serious offences where even an acquittal may not undo the public censure and stigmatization caused by the severity of the charge. A similar policy adopted while Article 5.5 of the European Convention of Human Rights has successfully deterred the state from sidestepping its obligation and encouraging excessive detention, and has reinforced the importance of safeguarding the presumption of innocence regardless of the gravity of the allegations. Now in India, the rate of conviction unfortunately is less than 10%, which is shocking, which obviously goes to show that the huge number of arrests which are made are totally unnecessary and uncalled for. I think I've spoken enough for today, and I would request Mr. Luthra, I think, should take over now. Thank you.
Thank you, sir, for your eloquent views and telling us how judicial discretion is exercised selectively. As per my scholarship, the reason why this judicial discretion is exercised selectively or disparately is because of the ambivalent nature of the liberal theory of criminal law. Thank you, sir, for sharing your views. Now I request Dr. Shruti Bedi to introduce Mr. Sidharth Luthra.
Be unmuted. Okay, thank you. Thank you so much, Dr. Chirag. Thank you so much, Mr. Sanjeev Singh, for such a brilliant exposition, and Professor Manoj Sinha for speaking to us and discussing the main issues which are involved in the bail jurisprudence in India. I would briefly like to take this opportunity to highlight a book and also welcome Mr. Sidharth Luthra, the senior advocate and the man behind this very book, Taking Bail Seriously. I am putting up this book for everyone to see on screen. He has joined us. We welcome you, sir. I know that you wear your brilliance effortlessly, but as we were saying, that the book which has been dedicated to your father, Mr. K.K. Luthra, is a small token of his own contribution to the field of criminal law. You, sir, have taken the legacy forward and are building upon it. And we are so thankful to you to be a part of this very discussion on the book, issue of the book, as well as today's panel discussion. On behalf of the entire team, I express my gratitude to you, sir, and welcome you. And also express our thanks for having left your busy schedule. I know you've been in the middle of a court case and you have joined us now. So without any further ado on my part, I would request Mr. Sidharth Luthra or Mr. Dr. Chirag Balyan to please invite Mr. Luthra on the platform.
Sir, please.
Good evening, all. My dear friend, my dear friend Sanjeev Singh, who has spoken so eloquently. I had the privilege of hearing him at length. Professor Bedi, Professor Balyan, Professor Malik, Professor Sinha, perhaps not in the order, but I must thank you all for, and all the listeners, I must thank you all for indulging me. I'm actually caught in the middle of a peculiar hearing, which is just not stopping. So I've escaped for a little while. And Sanjeev has been very kind to cut short his talk and indulge me. My understanding of bail jurisprudence is the jurisprudence of liberty of Article 21. But where has that liberty gone? Where has that understanding gone? If you look at the 1980s, you had, as Sanjeev rightly pointed out, you had this glorious tradition where people talked about liberty, about the rights of individuals, how bail should be the rule and jail the exception. Today, barring individual approaches of certain judges and courts, that has now been narrowed down, and the philosophy of the court in its entirety, and the Supreme Court sends a signal for the entire country, has changed from being pro-liberty to being cautious. Part of it has to do with the changes that liberalization brought in the economy, and we started focusing on economic and white-collar crime. But it's not just 1990s. By the late 80s, this change had started coming, and I have seen it as a student of the law when I was studying law, and thereafter, as I continue to be a student of law while as a practitioner of law. Today, we are still fighting. We have the Constitution in 1950. We're still fighting for fundamental things. I don't know if any of you had occasion to see yesterday, I did a PIL in the Delhi High Court, and what were we asking for? We were asked day before we did it. All we were asking for was give us copies of the replies furnished in response to our bail applications. Give us copy of the report which is furnished by the jailer or by any third authority called for by court. And these are not being given as a matter of course even today. They are not being given as a matter of course because the High Court rules have not made provision for this. In fact, the High Court rules, Panjab High Court rules followed in Delhi, Lahore and Punjab and Delhi, make it very clear that bail matters must be taken on expedition, on priority. And, there's this beautiful old decision, 1989 Ayaz case, which says that when liberty is at stake, you must give it priority. You must not defer or delay. It is to be taken out of turn and heard. Of course, today when matters of liberty are taken out of turn and heard, then there's a furor in the media that why have these matters been taken out of turn and heard? So there are issues and concerns. People want justice to be equal, but there are two ways to it. Now, I ask myself one question: why did we have to move the Delhi High Court? Because you know why? Because in COVID, we showed a series of orders where judges record a simple one-line order: bail application, reply received, report received, bail dismissed. What does normally in normal courts we would go, we would be physically present, we would ask for a copy. Now, what is asking for a copy entail? It means procedurally that there is going to be a deferral, there's going to be another date. And meanwhile, somebody's rotting in custody. Is this liberty? Is this the right of bail which individuals are entitled to? Is this in consonance with the principle of presumption of innocence? Today, the CRPC and the laws, criminal laws are being re-looked at. There's a committee which is looking at it. And having seen the way the Malimat committee has gone and having seen how the law has developed, I'm increasingly concerned about the restrictive application of laws and interpretation of bail provisions. So we've had two interesting changes. One, most statutes are diluting the presumption of innocence. That has a great impact on bail. The presumption is now that you are guilty and you have to prove your innocence. Now, it's all very well at the stage when you're facing a trial, when you have evidence. But at the stage of bail, before the trial begins, all the state does is says, we have the foundational facts. There is a presumption that the person has committed offense. Where are you going to get bail in such cases? So you have provisions, stringent provisions such as 212 of the Companies Act, presently under challenge. The PMLA provision was struck down. We will see what happens to the next challenge because they brought it back through the back door. And 212 is under challenge. It's coming on the 6th of July. So that has yet to be seen what is going to come. But the twin conditions of proving your innocence at the stage of bail and a presumption that you've committed an offense and that you won't commit it again are things which constrain the right to bail so stringently that it creates an apprehension of an individual. Are you ever going to get out till the trial is over? There is, of course, as Sanjeev rightly pointed out, a change in the COVID era. Very important. And I'm going to dwell on that in a moment. But before that, I want to deal with the Sushila Agarwal case. Now, one of the important judgments that we have seen is the judgment on anticipatory bail, the Constitution Bench in 2020 on Sushila Agarwal's case. It's a very fascinating decision. But what is it? To use a phrase a young man told me recently, is it nothing more than old wine in a new bottle? After a lot of talk about human liberty and rights and bail, the court has gone on to essentially reiterate SIBIA, but according to me, limit SIBIA. According to me, to constrain the discretion SIBIA had. I also wish there was an interpretation in the context of the 2005 and 2018 amendments to the CRPC. That, of course, has been touched but not dwelt upon, and that leaves the Pandora's box open for another day. So therefore, my concern is that even while the legislature constrains, courts also are not as liberal as they ought to be. They just don't show the level of, there is consideration. I must say this recently, I did a case for a journalist and the court has given us a stay of investigation, initially stay of coercive process and stay of investigation on the first day. The Supreme Court in the 32 petition. And I was happy to see I must say, I was the lawyer for the person, but I was also happy to see the sensitivity of the court to human liberty. Multiple FIRs have been registered. So the sensitivity of the court is today a much more important value in our criminal justice system, keeping in view that the legislature is increasingly enacting more and more stringent laws and processes which restrict the right of bail and restrict human liberty. I had mentioned COVID and Sanjeev spoke about it at some length. It's a very interesting thing. I attended a seminar, even in the UK, in Cambridge. They've let out about 10% of their prison population. We don't know our statistics. We're doing decently well. I don't know how well. But the COVID era intervention by the Honorable Supreme Court has come at a very crucial time. One thing was very clear. Government is relatively slow to act, so it had to be a court-ordered intervention. And it has paved the path for release of many, many people. Now, I leave a question open for the audience because all of you are young lawyers and I expect that some of you will be guided by Professor Bedi, Professor Balyan, Professor Sinha, Professor Malik, to do some thorough research. Has the release of all these people not told us one very important lesson, that our jails are overcrowded? If so, what are we going to do about it? How is the criminal justice system going to react to this overcrowding of jail, which we know is a long-standing problem, partly legislative, partly judicial? Secondly, now that people have been released, there are figures floating around. The last figures for people in custody are 2016, 17. We don't have I couldn't find the latest figures. I wrote about this as well. So when the last figures are old and we don't even know the exact number of people in custody, and we have released, let's say 5-10%, whatever the case may be, this is a legitimate question arises. Has the rate of crime, has the rate of recidivism gone up? And if the principle is that a person should not be kept in custody if his trial is not proceeding, then why is it that only 5 or 10%? As Sanjeev pointed out some examples, why not more? And what are we going to achieve by keeping people who have comorbidities, who are more at risk in the COVID era, in custody? I'm just in the process today, right now as we speak, of doing a matter for bail. I'll go back to it in a moment. And one of the issues is the person is an injury who's undergone a procedure. Should that person be directed to custody at all? If there's no flight risk, if there's no other dangerous circumstance. So my request to all the listeners here, and especially the young students, is when this COVID era, as this COVID era continues, we must relook at fundamental issues regarding human liberty, regarding incarceration, regarding a stringent legislative approach, and a cautious judicial approach to the grant of bail. All of these must be analyzed, and you must get back to us with the data on recidivism, on the impact on trials, on the impact on liberty, on the impact on people fleeing from justice, and the impact on society. That's all I have to say today. Thank you very much.
Thank you, sir, for sharing your ideas. And in fact, when you talked about that, how the movement grew after liberalization, privatization, globalization, there's an increasing trend of presumption of guilt. It takes me to the point of a general problem of criminal law, which we refer as over-criminalization. And this bail jurisprudence is becoming part of that, is contributing to that. And 67% under trial population is testament to this fact. Thank you so much, sir, for sharing your views. Now,
may I take your liberty? I have to get back to that hearing, if you don't mind.
Sure, sir. Sure.
And of my dear friends, Sanjiv, Mr. Sheikh, and the professor.
Unfortunately, I cannot hear any of you clearly.
Sanjiv, I'm going to have to run away to court. I'm in the middle of a hearing, so you'll excuse me. That's what I was saying.
No problem, but I am not being able to hear any of you. Unfortunately, there's a problem in the... Can you hear me?
I can hear you. You're very clear. Video and audio both.
There's some problem with the incoming audio.
You're looking as good as you always do.
So,
Chirag, we cannot hear you. Yeah.
hello.
Yes, please.
Yes. Am I audible?
Yes, you're audible.
Thank you, sir, for joining us. And we really understand that you have a court proceedings to join. Now, we'll be having some questions from the audience. So if anybody has any question, they can post in the chat box.
Yeah, thank you, Chirag. Already we have a few questions. If you permit, may I just announce those very questions, and maybe you can decide who will answer that. Is it all right?
They can pose the question directly to the speaker. I think they can name the speaker. That would be better.
Okay. All right. So while the participants ask question, there are a few questions which you already have. Can we take one or two?
Sajid, would you like to read the question or should I read?
Yes, I can read. There is a question by person named Bharati. The question is, under which grounds bail can be rejected? Is there any provision for rejection of bail? So I think some part of it Advocate Sen already discussed. So, sir, could you throw a more light on that?
The question is open to the panelists, whomsoever want to answer.
Yeah.
Yes.
Sanjeev
Chirag.
would answer that.
Yes,
Hello.
I am unable to hear, so unfortunately, I'm not. The voice is not coming to me. So I would request Mr. Luthra to answer.
So as I take it, the question was on the refusal of bail or grant of bail. I'm sorry, I also had a little disturbance there.
Refusal of bail, sir.
There has been a change in consideration on how bail is to be granted or refused. Originally, the fact of stage of trial, the fact of period of custody, the fact of presumption of innocence, the fact of pro-liberty philosophy was there. Today, it has been overridden by seriousness of the offense, which is becoming the primary consideration for grant of bail, whether a person flees from custody or not. Those have all taken second stage. So the traditional parameters which were drafted and put in all bail applications, which was that I will not flee from justice, I will cooperate with the investigation, I will not tamper with evidence. Tampering, of course, a threat of tampering is relevant, but more than that, the seriousness or the heinousness of the offense has now become the primary consideration for refusal or grant of bail. And that leads to a very interesting thing that leads to a complete negation of the presumption of innocence as we knew it. So while there are legislations where the presumption of innocence is being diluted by a reverse burden, but in those legislations where there is no reverse burden, seriousness can be one of the considerations, but not the primary and the over-encompassing consideration. But that needs re-examination and recalibration.
thank you so much, sir, for your lucid response. Another question is by Shweta. She asked whether one can leave the state if he or she is on bail.
One can leave the
State.
city. Okay. The grant of bail encompasses certain conditions. There can be a restriction on your remaining in the state, and if that is there, then you can only leave with permission. If there is no such restriction, you can't be restrained from moving about, provided you attend to the hearings, provided you cooperate in the investigation or cooperate in the hearings of the case. But there are provision, and now under 438 as amended, there is a requirement to place this condition of restriction of travel abroad or travel mandatorily. Passports can't be retained. That's settled in Suresh Nanda's case, but the restriction can be imposed by the judge.
So we'll take one last question because of the paucity of the time. And the question pertains to the difference of bail procedure in the juvenile justice law and the Code of Criminal Procedure. As we know, under Section 12, there is a presumption, specific presumption in favor of bail. Should that also be extended to normal CRPC?
Sorry, I missed the question. Can you repeat? Which
Distinction,
statute are you talking about?
I'm talking about distinction of procedure of bail in JJ Act and CRPC.
JJ Act. Anybody else will answer? Should I answer that?
Sanjeev Singh is not able to hear properly, so.
Yeah, I think his frame is frozen. Anybody else wants to venture, or should I give it a shot? Sanjeev, would you like to answer that?
I can't hear anything what is being said because there's a problem with the incoming voice.
Okay. Should I give it a shot?
Sure, sir, sure.
The JJ Act contains a very important provision in relation to the approach to bail, which is part of your legislative mandate under juvenile justice, and that's internationally recognized. There has been a stringency even in that by creating an exception for prosecution by normal courts in the age group of 16 to 18, which is amendment, which has been brought by an amendment. But that part, the JJ Act, seeks to have a more liberal approach to the grant of bail. The question will be, in the absence of any such provision, should we not veer towards the side of granting bail rather than not in non-JJ Act offences? Now, the fact is, there is now time to have such a statutory provision brought in, because in the absence of such a provision, we are finding there is a stringent approach, and it is now becoming more and more important that there is a legislative recognition for a liberal approach to the grant of bail, and therefore an amendment of this nature would be, I hope, considered by the committee which is looking at criminal justice and criminal law reform. Can I now run back to my hearing if you don't mind?
Hello, we can take last question.
Can I skip to my hearing if you don't mind?
Sure, sir.
Okay. Thank you so much, everyone.
Thank you.
Thank you.
Sajid, can you propose vote of thanks?
Yeah. So,
yes. एक second, एक last question ले लेते हैं.
Yes, please.
Should the order of bail be speaking order?
Yes, of course. Mr. Chirag?
Yes, sir.
It goes without saying that should be a speaking order. If the judge refuses the bail, then he or she is bound to give the reasons, and it is always better that the order should be speaking order, so that the aggrieved person can, even if he is not satisfied, he can challenge the validity of in the higher court.
Sure. Thank you, sir.
So can we take one more question? And
I think Sajid, if you can just now propose vote of thanks.
okay. Well, thank you all the speakers, especially Mr. Luthra. We could see that he was outside the courtroom in his busy schedule. He still, graced us with his presence and spoke about bail laws and bail jurisprudence. Thank you so much to Advocate Singh for again discussing about the bail jurisprudence and certain other related matters, and also discussing about the various few cases which are very much popular in the media. So also thank you, Professor Bedi and Professor Lokendra Malik. It has been a very good collaboration. I congratulate you all for your book also on taking bail seriously. I hope that all the academic institutions, take benefit of this very book. Thank you so much, Professor Sinha, for your views on the international perspective related to the bail laws. Professor Bedi, I think she's on mute. Thank you so much to you also. Last and not the least, thank you so much, Chirag, for moderating this very session. I hope that we have discussion like this again and again on various topics. I could see that we had more than like 250 participants in this very webinar. And in the very beginning, I said that we had arranged this very webinar in a very short span of time. Again, after this very webinar, there must be a lot of questions. I can see I wanted like a few more questions to be taken up, but of course I can understand that we have paucity of time. A lot of people are very inquisitive about all these very issues which are happening, like the bail matter of Safura Zargar, and recently the what happened in Tamil Nadu with Jayaraman and Benix. It has made us question about the judicial approach, about the power of police, and many other issues. I hope that law students and academicians and all the legal fraternity will take up these very matters, will write about it. Of course, as academicians, as legal professionals, what we can do is write about it. We can spread more awareness about the rights available, about the duties which are to be enforced. So I take this occasion to thank all the participants for sparing their time, listening to all the speakers. And of course, we'll be sharing to all of you a feedback link. You can send your feedback there. Thank you all. Have a nice evening.
Professor Sheikh, please, hello, Professor Sheikh.
Yes, sir. Yes, sir. Yes, sir. I'm listening to you.
Please say a few words of thanks to all the distinguished participants. I've seen hundreds of people have joined us. So we are deeply grateful to all of them, and also share some information about our book. This Taking Bail Seriously is published by LexisNexis company, and it is available online also on Amazon and all other online platforms. Okay, and this book gives some very important information regarding bail jurisprudence. Thank you very much. Thank you to all of you.
Thank you. Bye bye.
Thank you, everyone. Okay, so.
Thank you.
So I request everyone, you can leave this very meeting now. I will be emailing you the feedback link, and the certificates will be provided to you within a week on the registered email ID which has been sent by. Thank you.